Hello and welcome to the YouTube channel of Vidhi Culture. We are again here with you with the important topics of the family law, which we were discussing before. Because as you know that DU LL.B examination 2022 is going to happen very soon, and also some other legal examinations. So it is very important that we must focus upon the very important topics of the family law, because many questions from the family law comes into these law entrance examinations. So in today's session, we will talk about one more important topic, that is the judicial separation, which is mentioned under Section 10 of Hindu Marriage Act 1955. So let's see what exactly this section talks about. That is the judicial separation. So let's see what is this judicial separation. So when we talk about the judicial separation, then we must know that it is mentioned under Section 10 of the Hindu Marriage Act. And what exactly this, this provision talks about. So what is judicial separation? Judicial separation is nothing but it's a medium under the law to give some time for the self analysis to both the couples in a marriage. So we can say that it's a medium under the law to give some self analysis time to both parties of disturbed married life. So when the married life is disturbed, then the couple can go to the court, or any of the party can go to the court for the judicial separation, that we want to separate for some time. It is not exactly the divorce, and the conditions are not like the divorce. But yes, in this provision also, if this judicial separation is granted, then definitely they have to live separately, and they will no more be obliged to live together. उनको साथ रहने की जरूरत उसके बाद नहीं है. सो इसके अंदर बेसिकली होता क्या है, दैट लॉ प्रोवाइड्स अनदर चांस. ठीक है, लॉ गिव्स यू एन अनदर चांस टू रीथिंक about your relationship and the extension of your relationship, and at the same time guiding you to live separately. So we can also say here that it gives a chance to both husband and wife to rethink about the extension of relationship, and at the same time guiding them to live separately. So this is the the motive of providing the provisions or provision of judicial separation, because once they live separately, so they get to know that whether they want the relationship back, or they want to live separately, or they are comfortable by living separately or not. So the court actually gives some time to them, कुछ time वहाँ पे दिया जाता है, and free space provide किया जाता है. तो basically इसके अंदर होता क्या है, that any of the party, any of the party, any party, any or either party, that is husband or wife, files a petition for judicial separation. जुडिशियल सेपरेशन के लिए कोई भी फाइल कर सकता है, एंड द ग्राउंड्स ऑफ जुडिशियल सेपरेशन की जब हम बात करते हैं, ग्राउंड्स ऑफ जुडिशियल सेपरेशन, इसकी जब हम बात करेंगे ग्राउंड्स ऑफ जुडिशियल सेपरेशन की, देन दीज ग्राउंड्स आर सेम एज इट इज फॉर द इट इज देयर फॉर द डाइवोर्स, जो कि आपके सेम सेम एज ग्राउंड्स ऑफ डाइवोर्स, like for example in section 13(1), these grounds are common grounds for both parties, दोनों parties के लिए same grounds होते हैं, but there are certain special grounds for the wife that is mentioned under section 13(2), only for wife. So on the similar grounds, the it can be filed, judicial separation भी यहाँ पे file किया जा सकता है. तो this is what the judicial separation talks about. It gives you certain time to decide whether you like to live separately or so. And अगर बीच में अगर दोनों parties में से किसी का मन बदल जाए, then they can make an application to court, and on the on by observing all the things and by being satisfied, the court can allow such application, and therefore they can live together again. So this is about the this particular provision of the judicial separation. It is very, very important. Now we will look at the what exactly the law says, kya exact wordings hai, that we will try and read and understand. As we have already understood, I have already told you that what exactly this means. Now we'll read that also, the bare act. So look at this judicial separation mentioned under section 10. So it says that either party to marriage, means either husband or wife, whether solemnized before or after the commencement of this act, इस act के आने से पहले या बाद में जब भी शादी हुई, may present a petition praying for the decree of judicial separation on any of the grounds specified in subsection 1 of section 13. तो सेक्शन 13 के सबसेक्शन 1 के अंतर्गत जितने भी ग्राउंड्स दिए गए हैं उसके अंदर कोई भी पार्टी चाहे तो वो पिटीशन डाल सकती है फॉर द जुडिशियल सेपरेशन मांग सकती है. एंड इन केस in case of wife also on the grounds specified in subsection 2, therefore as grounds on which petition for divorce might have been presented. So as I have told you, there are certain special grounds for the wife mentioned under section 13 subsection 13(2). So this was about the grounds. Now it says where a decree for judicial separation has been passed, जहां पे पास कर दी गई है, it shall be no longer obligatory for the petitioner to cohabit with the respondent. यहाँ पे साथ में रहने की जरूरत नहीं है अगर डिक्री यहाँ पे दे दी गई है, अगर डिक्री यहाँ पे अलाउ कर दी गई, there is no requirement of living together. But the court may, on the application of the petition of either party and on being satisfied of the truth, ठीक है, अगर कोई petition डाले कि हम वापस से दोबारा साथ में रहना चाहते हैं, then definitely the court can allow, taking into consideration the things mentioned in the application, The statements made in such petition rescind the decree if it considered it just and reasonable to do so. अगर कोर्ट को लगता है ये जस्ट एंड रीजनेबल है तो कोर्ट उस जो पहले वहां पे जुडिशियल सेपरेशन दिया गया था उसको वापस ले सकता है. So this was all about the judicial separation. I hope you all have understood this provision of the Hindu Marriage Act. It is important and it can come in your examination, or sometimes they also ask, they may ask directly section in which section the judicial separation is mentioned. So it is section 10 of Hindu Marriage Act 1955. So thank you so much. Thank you for joining, everyone. Bye bye. Take care.